the final round. That's a tremendous accomplishment. As you may recall, my name is Ben Glickman. I work for the California Attorney General's office, but much more importantly than that, I was on a national championship We the People team way back in 1995. So I've been on your side of the table, and I look forward to our conversation this morning.
Good morning, Colorado. Also, congratulations to you. My name is Gus Chin. I'm a municipal judge in Holiday, Utah, and I do look forward to engaging you this morning in a great conversation. Thank you.
And hello, my name is Andy Levy. I'm a trial lawyer in Baltimore, Maryland. I also teach at the University of Maryland School of Law.
If you'd please introduce yourselves and your teacher.
Hi, my name is Sarah Astris and I'm a junior.
My name is Ellie Goldstein and I'm a junior.
My name is Harlem Porter and I'm a junior.
My name is Lucian Frisbee and I'm a junior.
My name is Hazel Newman and I'm a junior.
My name is Madeline Rogers and I'm a junior. And our teachers are Mandy Hostetter and Matthew Fulford.
Great, and congratulations to the teachers as well. I know what a tremendous commitment We the People is for the teachers. So, all right, if you guys are ready, I'll go ahead and ask the question and we'll get going. The question we chose today is number 2. And it's dialogue at the beginning, but I'm just going to read it straight through. The facts are supposed to determine the case. Don't give me any of that. I'm sick and tired of facts. You can twist them any way you like. Know what I mean? That's exactly the point this gentleman has been making. Why are juries required to render a unanimous decision rather than a majority decision in most criminal cases? To what extent, if any, do jury trials ensure due process as stated in the Constitution and Bill of Rights? To what extent, if any, do jury trials reinforce founding principles? Whenever you're ready.
Juries are required to render unanimous decisions in criminal cases to protect fundamental due process rights for a fair trial, specifically proof beyond a reasonable doubt. The right to a jury trial is mentioned twice in the Constitution, in Article 3, Section 2, and the 6th Amendment, which was incorporated to apply in states in Duncan, Louisiana, 1968. And Ray Winch in 1970 held that the proof beyond a reasonable doubt standard must be upheld in all criminal proceedings. In 2018, Reynolds v. Louisiana established that the 6th Amendment requires a unanimous jury to not abridge the privileges or immunities of citizens without due process of law.
Prior to Ramos v. Louisiana, unanimous verdicts were not required in every state. In Apodaca v. Oregon, 1972, and Johnson v. Louisiana, 1972, the court held that a majority of 10 jurors was sufficient to render a defendant guilty. Non-unanimous juries, as enacted by Louisiana and Oregon, were designed to exclude the votes of non-white jurors. Due process established in the 5th and 14th Amendments ensures people's rights are protected. Additionally, the 4th, 5th, and 6th Amendments all state requirements of criminal proceedings, protecting the rights of the accused before and throughout trial.
The 1215 Magna Carta stressed the importance of a lawful judgment of one's peers. Additionally, the English Bill of Rights of 1689 expressed the importance of a diversity of one's peers, citing the failure of British juries as partial, corrupt, and unqualified persons that have been returned to serve on juries and trials. When the framers drafted the Constitution, they placed a great value on a jury of one's peers to ensure power to the people and not unchecked government authorities like King George III. Thomas Jefferson wrote to Thomas Paine, "I consider the trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its Constitution." Federalist 83 highlights the right of a jury trial as a valuable safeguard to liberty and the very palladium of free government.
However, jury trials do not fully live up to the founding ideal of a jury of one's peers. Certain occupations and relations are often excused, which can undermine impartiality in jury trials. The biased questions during the voir dire process can undermine a jury's impartiality. For example, Swain v. Alabama, 1965, held that implicit bias of jurors is compliant with the Equal Protection Clause of the 14th Amendment, thus allowing the ban of Black jurors and purposeful discrimination during the Jim Crow era. Prosecutors often find loopholes in precedent set to bar minority jurors without it being directly related to the juror's race. In Flowers v. Mississippi 2019, a list was found that targeted Black jurors to bar them from the jury despite seemingly race-neutral reasoning.
Strouder v. West Virginia, 1880, and Neal v. Delaware, 1880, recognized that race-based exclusion of jurors is a violation of the Equal Protection Clause of the 14th Amendment. Yet, during the jury selection process, peremptory challenges allow parties to ban jurors without explanation. Batson v. Kentucky, 1986, and J.B. v. Alabama, 1994, held that peremptory challenges cannot be used to eliminate jurors on the basis of race or gender. These standards were upheld in Foster v. Chapman, 2016. On the other hand, in Perkett v. Elam, 1995, the Supreme Court ruled that any race-neutral reason is justified, allowing the elimination of jurors based on race-related features.
It is important to recognize that 98% of all criminal trials end in plea deals, oftentimes because defendants are coerced into taking plea bargains. Along with allowing any race-neutral reason to be justified, plea bargains create tensions within the jury system. In Wild v. Wyoming, 1960, the Supreme Court recognized that the suppression of evidence prior to a defendant's guilty plea violates the Due Process Clause of the 14th Amendment. All these factors illuminate the importance of unanimous jury of one's peers. We are now open for questions.
Thank you. So you identified several problems with the current jury system, the misuse of peremptory challenges, the misuse of voir dire, the plea bargaining impact. What are your solutions to those problems? What would you do to improve the functioning of our jury system?
I think that the elimination of peremptory challenges could especially help this because in cases such as Swain v. Alabama, prosecutors are able to exclude people based on their race, and doesn't help a unanimous jury.
I actually disagree with my colleague, as in even before the jury selection process begins, 30% of Black jurors are excluded from being allowed to participate in juries because juries are often taken from DMV records or social security numbers. So I would actually argue that, like Arizona, which eliminated peremptory challenges on January 1st of 2022, despite this elimination, this ultimate fallacy of impartiality in juries has not actually been solved.
So instead of eliminating peremptory challenges, we can look to things like accessibility to serve on juries. It's not that people don't want to serve on juries most of the time, it's that people don't have the resources or ability to because of their situation. So if we were to give paid time off, childcare, and other ways that jurors could actually serve, we would be more likely to have a jury that best represents the society around us and is a true impartial jury of one's peers.
Given what you have just said, though, the mere fact that you may have a pool that may be diverse does not account for the seated jury being diverse. Do you see a problem with that, where the defendant is an individual of color?
There is definitely a problem with that. In order to ensure an impartial jury, we must promote civic education, but civic education that may increase the awareness of other situations that may be happening in jury trials. Additionally, there was a concern brought up during COVID saying, what if we had virtual trials? However, with virtual trials, that still does not provide the necessary means to be able to fully participate in jury trials.
As seen in the case of Strouder v. West Virginia, 1880, having a jury that is equally protected under various races and not having this protection is a violation of the Equal Protection Clause of the 14th Amendment, further expanded upon in Neal v. Delaware, therefore causing the maintenance of an impartial jury as practical to maintain the Sixth Amendment.
So let me ask you, so you are, if I understand it, you find peremptory challenges troubling because there's no need to give an explanation, and so it's a convenient way of striking a juror for an improper reason. Would you extend that to jury deliberations? Would you find anything troubling about the fact that juries deliberate in secret and are not required to explain their verdict?
Pena-Rodriguez did determine that the sanctity of the black box of the jury decision-making process is more important than truly anything else in our justice system, because it allows jurors to truly look at the evidence provided by the prosecutor and look at the defendant's argument and make a decision that best reflects the evidence that has been presented.
However, jury nullification can sometimes be used in the black box of a jury trial to undermine the idea of facts in a jury system. During the Prohibition era and during the Fugitive Slave Act, jury nullification was often used to undermine the actual law so that juries could convict or could deem individuals not guilty, even if the facts claim that the person is guilty because they do not agree with the law.
However, that is not an inherently bad thing. We can look towards the Prohibition Act and the Fugitive Slave Act ultimately having jury nullification being a good thing in the sense that abolitionists were able to determine the fact that the Fugitive Slave Act was canceled out through finding the defendant, having proof beyond a reasonable doubt that the defendant did indeed do the act, however, still finding them not guilty, ultimately to try and change the law in which was found guilty of.
But is that the
Go
way
ahead.
we want to change policy, by ignoring the law, choosing which laws we think are good and bad? Is that really what we should be encouraging? Changing law by jury nullification?
Definitely not through jury nullification. The only circumstance we should use jury nullification is if we find a jury not giving an impartial jury for the defendant. The point of a jury trial is to be able to protect a defendant's personal life and liberty. However, with jury nullification, that should further protect, ideally, a defendant's personal life, liberty. However, that's been oftentimes abused. Instead, through civic education, we can thus promote civic education, making these problems more aware. Additionally, the Constitution has been made to be amended. If we look back towards the founding fathers, I believe that Thomas Jefferson, James Madison, alongside with the other founding fathers, would be surprised to see that to this day, we have not amended to further fit a better democracy, a better impartial jury of one's peers to further protect our liberties.
However, I believe that in instances of jury nullification, it is important to take those into account because they are so important and fundamental into changing laws, such as in the Fugitive Slave Act, when juries would nullify so that slaves that were being taken in or slave holders would not be tried for the crime of holding slaves. And instances like those prove that jury nullification is fundamental to law changes.
Additionally, the founders put a great amount of value on the trial by jury system. And so we can look to juries to decide the morality of laws to some extent. And so jury nullification isn't inherently a bad thing necessarily. It just has to be used in very specific instances in order to make our justice system a more moral and equitable world for all of us.
Let me jump in with a question in that realm then. If the jury improperly convicts someone, should the judge be able to overturn that conviction?
The judge should be able to overturn this conviction as they have the final say in the guilty or not guilty verdict, and they can declare this as a mistrial, as seen in Flowers v. Mississippi 2019. He was tried 6 times for the same crime and was mistrialed for an impartial jury.
Let me have you pause it. So isn't the jury the final fact finder and decider regarding guilt and innocence?
The jury they determine the facts of the case and see if there's any proof beyond reasonable doubt. But if there is enough evidence proving that a defendant did or did not commit the crime, a judge is able to overturn a jury.
I would like to disagree with my colleague. The jury does not correct the facts of the case. Instead, it's the prosecutor's burden of proof to provide those facts of the case. And if there's an overwhelming amount of evidence, then it is the jury's job to decide if there is sufficient evidence to either convict or not convict the defendant.
I disagree with my colleague. In the case of Ring v. Arizona 2002, it was determined that the jury ultimately holds the ultimate fact-finding ability. In this case, which analyzed the death penalty of under the Eighth Amendment and the Sixth Amendment right to a trial by jury of your peers, it was deemed that the judge cannot ultimately decide the end sentence and instead leaves that power to the jury of your peers.
We've talked about criminal cases so far. So do the things you say, would you, first of all, is there a right to a jury trial in civil cases? And B, are the same things you said about the jury trial in criminal cases, would you apply those to civil cases?
When it comes to criminal trials, it was established in Thompson v. Utah in 1898 that a jury of 12 jurors was required, but this was overturned in Williams v. Florida in 1970, where it was deemed that 6 jurors could be possible in a criminal trial depending on the nature of the crime.
Ultimately, what we can understand is that in the 7th Amendment, there is an explicit right to a trial by jury. Moreover, we can understand that in civil cases, there is ultimately a spillover of a trial by jury being guaranteed as, again, in the Constitution under the 7th Amendment.
Would you
Under
be more
Minnesota-
comfortable, would you be more comfortable with a non-unanimous jury in civil cases than in criminal cases?
Most certainly, because in criminal cases, the defendant's life, liberty, and property is most at risk. However, in civil cases, that's not the case. Their punishment is not as risky as in criminal cases. So I think that I would be most comfortable with non-unanimous juries.
In Minnesota State Railroad v. Bombolis, it was decided that the civil trial is not as important as criminal trials because it does not incorporate the right to a civil trial to the states. However, in our state of Colorado, the right to a civil trial has been incorporated into the states.
Great.
Thank
Perfect
you
timing.
very much.
Nice job. Give you a thumbs up emoji.